investigation to understand what it is. Even the example I gave of ignoring the Customary Land Act, it shows that there are complex ways in which top-down and bottom-up regimes actually interact. Now, all these levels of social life are mutually constitutive, which means one level constitutes the other. But what I want to focus in terms of legal consciousness is that if we zoom in on the legal actor, we have this concept which comes from a well-known social theorist, a European social theorist, whom I'll talk about in the next slide. The concept of habitus, which is the constitutive of the actor's attitudes and relation on each of the levels that I've talked about. Now, habitus is different from habit. Habitus is a much broader concept of what I would call socially ingrained perspectives. Habit is a repetitive behavior. So, it is very suitable for investigating legal consciousness because it is in terms of methodology, constructivist, not positivist. I'm sure if you have a PhD, you know what that means. So, the focus is on subjective legal experiences and the meaning that they hold for individual actors. So, within this, we have social theory, broadly understood as the choice, a possible way of studying legal experiences and the meanings that they hold for actors. So I'm focusing on one theorist, a European theorist. I'm sorry if I'm not pronouncing the name correctly. Pierre Bourdieu, others as they say it. And I'm particularly interested in his work because when I came across what he wrote, a book called Algeria, 1960, Disenchantment of the World. This was a very big eye-opener for him. Why? As to quote him, he witnessed a veritable social experiment showing a mismatch between dispositions developed in a specific form of social organization, which are not readily transferable to an imported or imposed form of social organization. This, he could as well have been talking about law, because the post-colonial experience is that of imposed legal regimes for the various purposes such as the subjugation, which not only acted at the level of regimes, but also acted at the micro and the meso level to create all kinds of challenges. And with the former end of independence, that disposition that was acquired during the colonial period did not disappear. Because one of the mistakes by legal positivism is that you have legal change, transformation is assumed, but we cannot assume transformation. And Africa probably bears witness to this. There have been many formal reforms, but in some cases led to total dissatisfaction, even mistrust of law. I mean, we have examples from West Africa where even illegitimate toppling of governments has popular support. But these are very beautiful neoliberal constitutions. So text isn't much if we cannot think of the legal context in which they operate. So, the social interactions, including legal interactions, are a product of learning in specific social space. Somebody talked about space. And there's also the concept of social capital that Pierre Bourdieu talks about, which are resources or benefits. Because for you to be able to interact and produce effects, you must have capital in relation to that social space. If you don't, you are likely just to be watching, and you'll probably be completely dissatisfied with where you are. So, habitus has the potential to reconceptualize legal experience at each of the three levels that I talked about, including the aspects of perceptions or ordering worldviews. So this is an article that will be 6,000 to 8,000 words. I've just prepared these slides to give you a bit of introduction to what I'm going to talk about. It's going to be very radical, but I can assure you that there'll be plenty of evidence to back it up because it's simply true. So thank you very much. I think I'll stop there.
Thank you for this very short, very precise talk. You were under 10 minutes. So my next speaker on the list we're going to ask is Lea Mwambene. I hope I pronounce it okay, at least. She's a professor of law at the University of Western Cape in South Africa. And also, this is something which I'm very curious about when we talk about this, member of the Advisory Committee on Matrimonial Property of the South African Reform Commission since April 2021. So I'm very happy to have you here and talking about the intersection of human rights and African customary rules and practices. So let us hear about challenges and opportunities.
All right, thank you, and thank you, everyone, and to the organizers for the opportunity to present and to come back to Beirut in 2025. After what Cyprian has presented and after the presentation that we had, it's like I'll be repeating what they have said, this bottom-up approach and the fact that law, what we think is the reform of law is basically the repeat of what was happening during the colonial time. So starting with my presentation, maybe forget about the title. So historically, customary law, as we generally know, and for the sake of those who are unfamiliar, I'll be going through some of the stuff that is obvious to others, has been viewed as insufficient in dealing with human rights violations. And in South Africa, as well as many other African jurisdictions, courts and legislative approaches try to address the conflict between customary law and human rights by replacing customary law with common law principles or invalidating customary laws in the court cases, or acknowledge that customary law has evolved to reflect human rights norms of gender equality, when in actual fact what the courts are doing is that they are changing the essence of what customary law is. So whilst the work of many scholars applaud these legislative and judicial approaches in addressing the human rights violations, what is challenging is that communities that are governed by customary laws are not given the opportunity or space to develop their own customary laws. And against this background, in this paper, I ask, how can African customary rules and values be recognized and included in the law reform processes while simultaneously addressing issues of inequality, non-discrimination, and the protection of human rights? So the focus of my discussion today will be on marriage and succession law reform that has taken place in South Africa, as well as touching on few cases to demonstrate the steps taken to address the human rights violations within the context of African customary law in South Africa. So by way of, okay, so that's the structure of my presentation. So by way of introduction, so African customary laws has long been, dating back to pre-colonial times, has long been seen to have this rich history And these customary laws were developed and practiced by African communities and were often based on traditional norms, values, and practices. And customary laws played significant role in governing social relations, resolving disputes, and promoting community cohesion. However, the arrival of colonialism had impact on the African customary laws. Colonial powers imposed their own legal systems on the colonized societies, often disregarding the existing customary law practices. This led to some kind of conflict between customary law and the Western legal systems. And that conflict, we see that it still continues to the present day. And in addition to that, the international human rights community has always viewed women or communities governed by customary law as active members of their cultural communities, have always not viewed them as active members of their cultural communities. Instead, these communities or women have been viewed as victims of their own culture. So this perception, unfortunately, undervalues the potential for the communities or the African women to reformulate cultural policies within communities, and that's what I took from Professor Bond. Now, at the international level and regional level, on the position of international human rights law and customary rules and practices, it is important to note that many instruments recognize the application and relevance of cultural rights and cultural practices, but subject them to human rights standards. For example, the African Charter on the Rights of and Welfare of the Child, the Protocol to the African Charter on Human and People's Rights, contains these provisions relating to the elimination of harmful cultural practices, including prohibition through legislative measures backed by sanctions, all of the forms of harmful practices that negatively affect the human rights of women and children, which are contrary to the recognized international standards. And in addition to that, in addition to the substantive rights provided, for example, in the protocol to the African Charter, we see that there are important procedural rights to ensure that women, and I read in communities, have a voice in the ongoing examination of reformulation of cultural practices and customary laws. So what has been the approach to the law reform of customary rules and practices? So as way of background, to understand the current exclusion of African values and communities in the reform process, my starting point is the quote by Justice Moseneke in the case of Gumedi versus the president, and I quote, who said that during colonial times, the great difficulty resided in the fact that customary law was entirely prevented from evolving and adapting as the changing circumstances of the communities required. It was recorded and enforced by those who neither practiced it nor were bound by it. Those who were bound by customary law had no power to adapt it. Official customary law was left unreformed, stonewalled by static rules and judicial precedent, which had little or nothing to do with the lived experiences of spouses and children within the customary marriages. Now, so what are the kind of issues, the human rights issues between customary rules of succession and marriage that we see? So basically, the list is exhaustive, but I've just highlighted 3. So the human rights concerns surrounding the succession and marriage laws are under polygyny, the issue of consent, the issue of bride price, and as well as the issue of the male primogeniture. So for the sake of those who are not familiar with the African system, the issue of consent is whereby traditionally the consent of a bride, a prospective bride, was not an essential requirement for the validity of a customary marriage. So the essential requirement, the essential consent was from the father of the bride. That is debatable and is a discussion for another day, because the women would give consent in ways that would be understood by the communities, but it was in the official customary law, it is portrayed as if women never gave consent. But this is what is in the official customary law. Now on polygyny, polygyny is a practice whereby the man is allowed to have more than one wife. We heard earlier from Msika that in Kenya they have adopted the reality, and the reality that polygamy is part of the African culture. So in Kenya, polygamy is kind of recognized, and as well as the bride price and the male primogeniture. So the male primogeniture under the rules of succession is when the inheritance succession goes through the firstborn son of the family head. So to the exclusion of women and younger children of a particular deceased family head. Now, by way of background, before the 1996 constitutional dispensation in South Africa, legislation for customary marriages was already in place. The colonial attitude, however, towards the institutions of lobolo, polygyny, and consent led to non-recognition of customary marriages as valid marriages. So the effect of this non-recognition of customary marriages meant that customary wives and children were placed in a disadvantaged position. If a husband was a spouse in an existing civil marriage, any subsequent customary marriage was void. And if a civil marriage was concluded while there was a subsisting customary marriage, the customary marriage becomes void. In addition to that, customary wives were regarded as perpetual minors with limited legal capacity, subject to their husband's guardianship. So since the transition to democracy in 1994, the 1996 Constitution recognizes the legitimacy of customary marriages under Section 15, subsection 3. And this recognition is subjected to what would say the repugnancy clause, which comes with the Bill of Rights. So it's recognized but subjected to the provisions of the Constitution. So coming to the reform of some of the customary marriage and succession rules. So the interventions to address the human rights violations has been through the recognition of Customary Marriages Act for customary marriages and the Reform of Succession Act of 2009. So in the recognition of Customary Marriages Act, we see that lobolo is not specifically recognized as the requirement for the validity of a customary marriage. Section 1 of the Act defines lobolo, but when we look at section 3 that provides for the requirements, then the act is silent there. And this has led to courts recognizing as valid marriages in which the requirement of lobolo and other customary ceremonies which are regarded as essential requirements for the validity of the marriage not to be made, which may have implications, coming to the theme of the belonging, which may have implications on where these women and children born from these unions belong. Because lobolo, the requirement of lobolo, was the one that would determine the rights and responsibilities of the father and to also determine where the particular children belong. Another example is on polygyny. So the Recognition of Customary Marriages Act recognizes and regulates polygyny. Within this context, courts have pronounced as a requirement for the validity of a subsequent wife that the first wife give her consent for the husband to marry a subsequent wife in the case of Mairani versus Wenyama. So this is despite the evidence from the community that the requirement under the Tsonga custom where these parties were coming from was that the husband must inform the wife, not necessarily for the wife to give consent. In addition, we see that legislation and courts in Gumedi and the Ramihovi cases have replaced the customary rules for the regulation of rights to property in a customary marriage with civil law proprietary consequences. This is without taking into account the practical realities of implementing civil law tradition and values, which may lead to exclusion and more rights to property violations. And so what comes from the jurisprudence from the court and the approach that has been taken by legislation is that these reforms do not take into account the cultural values, which, as Himonga calls them, reduces the reform to paper laws, with no implications on the enjoyment of human rights of vulnerable parties affected by discriminatory customary practices. To conclude, the straightforward formal approach is not satisfactory. Moreover, and as generally observed by many commentators, addressing human rights violations within the context of African customary marriage succession rules requires engagement with the communities in order to understand the reasons for the support of customs that may seem to violate their human rights and how best those customs can be changed in conjunction with their involvement, because communities, research has shown that communities out there, they are not resistant to change. It's the top-down approach, which they kind of not like because they don't understand why certain things should be done in certain ways. And also to engage with the role of traditional leaders, because we saw yesterday in the movie, the role of traditional leaders. If they're not coming to the party, if they just like what was happening during the colonial period, that the colonialists would engage with the traditional leaders and impose whatever they want to impose. Now, what we see is that law reform is done and maybe traditional leaders get involved at a certain level, but the communities are not involved, and which leads to resistance. And also empowering the marginalized voices within the community. Mantua yesterday, we saw in the search to try and get aid, she was at all times prevented from doing so. And also to have practical strategies for community-driven change, and measuring after that to measure the effectiveness of this participatory approach. I thank you for listening to the presentation. Thank you.
Thank you very much. So now from marriage and heritage, we move on to sustainability and mining. So it's quite a big jump. And I'm very happy to have one of our Bayreuth's own here, Ange Dorine Irakoze. She's a PhD candidate at the Chair of African Legal Studies and works there on mining governance and on sustainability. So it's something which is very close to what I understand, hopefully. And she's also an advocate at the Burundi Bar Association, I learned, so can give some practical insights as well. So I'm very happy to have you here. Floor is all yours.
Okay, thank you. Good afternoon, everyone. Okay, now we are going to just have a bunch of discussion about Ubuntu, mineral resources, but also environmental justice. So I'll start with mineral resources. I know that we all know what mineral resources is, but if we bring them into our practical, lives, for example, for lunch, we all had some drinks, either in the bottles or in the glasses. So glasses are made from melted quartz sand. We also ate from maybe plates, but when they are ceramic plates, they are created from clay minerals heated at high temperatures. And we all have phones. Phones are also made out of minerals. So these are all benefits we are getting from mineral resources. But do we really know the impact of the process for us to get where we are? So this is the impact. This is the connection between the final product, the phones we have, and the environmental impact. So this mineral resources, the extraction of mineral resources has a conflicted and often adversarial relationship with environment. We've seen it from previous speakers. So it has impact on the environment, the pollution, but also some chemicals which are used to transform them. It affects not only the environment, but also the health system of the communities. So in this ecosystem, African mineral development, they perpetrate environmental injustices because the environmental injustice happen when external costs are being affected by communities while we enjoy the benefits. So communities are frequently displaced without just compensation. I think we've seen it from the movie yesterday, though it was a dam. So this exclusion continues structural inequalities and reproduces colonial modalities of exploitation. It means that many Africans are are displaced from their homeland and experiencing a loss of cultural identity. So this brings a sense of not belonging at all, where communities are stripped from their land, health, and autonomy in the name of what we can call progress. But beyond that, beyond these environmental injustices, there is a deep ethical and moral concerns that go beyond the ecological harm, challenging core principles of human dignity, rights, and justice. Power imbalances allow mining projects to proceed without informed community consent, often exploiting the vulnerability of political or economically minorities groups. These practices reflect neo-colonial dynamics, where external actors take profit while local populations bear the costs. So the result is what we have seen, the environmental degradation, which has also an impact on basic human rights, including access to clean air, water, a healthy environment, while also threatening cultural survival and the rights of future generations. Environmental injustices and ethical challenges can also be traced from the normative frameworks governing mineral resources in Africa, largely due to structural and procedural gaps rooted in colonial era legal system, because most of the normative frameworks are viewed based on the colonial laws. And sometimes when some countries rich in mineral resources want to change their policies, you always see external actors coming in the name of adding certain international legal standards. But these are colonial powers in another forms. So these frameworks often prioritize resource extraction over environmental protection with those international standards, with weak enforcement policies, and with moral double standards compared to global north practices. For example, in mineral resources development, a same mining company operating, let's say, in Europe will have a double standard when the same activities are being carried out in Africa. So cultural clashes arise when Western legal norms override indigenous values. Procedural gaps such as lack of informed consent, limited access to information, and restricted legal standing undermine community participation and justice. And at the regional level, at the continental level, the African Union has made notable progress in addressing the environmental injustices in mineral resource development by incorporating ethical and moral principles into policies and institutions. Key frameworks like African Mining Visions, the Constitutive Act of African Union, the revised African Convention on Conservation of Natural recognize community rights. They recognize indigenous rights and also intergenerational equity, marking a moral shift towards inclusivity, a certain sense of belonging. Procedural improvements such as mandatory environmental impact assessment, we've talked about this earlier, and community consultations reflect a commitment to inform participation and justice. Additional tools like African Mineral Governance Framework promote transparency and accountability, helping to correct historical power imbalances in resource governance. But still, moral and ethical gaps persist. So despite this normative framework, there's still tension. A profound tension remains between moral aspirations and their practical realization. The gap between the AU articulated principles and their inconsistent enforcement exposes a fundamental contradiction, casting doubt in the integrity of its institutions. The national sovereignty, in the name of the national sovereignty, countries can adopt some international legal frameworks, but on their normal cases. And sometimes there's still power imbalances between multinational corporations and local population, which is reflected in enduring moral dilemma, one compounded by the African Union inability to fully confront the neo-colonial dynamics that shape these relationships. Now, what could be a path forward? Let's go back to our history. In this paper, I'm suggesting we adopt Ubuntu, not in its traditional form, but as a lived experience on the continent. We know Ubuntu means I am because you are. And in Ubuntu, humanity includes human beings, living and non-living beings, meaning the natural, the environment. So how can we use Ubuntu? How can we use African lived experience to undo these injustices? My proposal is to explore the Ubuntu philosophy as one among other paths forward, because one can use Ubuntu, but we have others, maybe policies which can be used. Ubuntu understands human beings as part of a whole system of relationships and interconnections in which they are responsible for the well-being and of all, including non-human beings. I'm suggesting that we think differently in terms of mineral resource governance in Africa through the lens of Ubuntu, a deeply rooted African philosophy centered on human dignity, relationship, this interconnection between human beings and nature, the communal well-being. This approach calls for aligning mineral resources policies with ethical principles that put forward environmental conservation, social equity, and the rights of affected communities. It emphasizes the need to move beyond extractive, beyond profit-driven models towards a framework that gives the value to shared responsibility, mutual care, and justice for both our generation, but also the next generation. So by incorporating Ubuntu ethics in mineral resource frameworks, we can do justice to environmental injustices. We can undo injustices. We can draft frameworks with more inclusive, culturally grounded, and morally accountable pathways to sustainable development. Here, I'm proposing that an Ubuntu-based approach to mineral resource development should redefine environmental justice, but by emphasizing the principle of belonging to community, to land, and intergenerational way of life. It's rooted in a relationship, and Ubuntu holds that human being is connected from the health of the community and the ecosystem, framing people as part of the land rather than owners of it. It extends the notion of justice beyond the fair distribution of resources to include the preservation of relationships that sustain identity and connection. It also calls for recognition of diverse cultural ties to the environment and insists on inclusivity, decision-making that honor participation for both generations. And by this framework, these relationships of belonging in Ubuntu-based mineral resource governance and framework can help heal historical wounds, address present injustices, and create foundations for a more just and sustainable future for African communities and environment. Thank you.
So for our last speaker, we need some technical support, and so it will be online. I'm very happy to have as our fourth speaker Bonolo Dinokopila. He's a graduate from the University of Botswana and has large expertise in international law, in human rights, and constitutional law. He was for 4 years, the head of the Department of Law at the University of Botswana, and at the moment he's a legal consultant at some law firms, I think also in Botswana. Spam you me trying to pronounce the name of the law firm, so you can all read it up, and I think it's better for everyone. So I'm happy to hear about Indigenous belonging and burial rights, a commentary on faiths. And floor is all yours. I hope the technique works. So.
Good afternoon. I hope you can hear and see me. Good afternoon.
Yes.
Yeah.
Yeah, we can
Yeah.
hear and see you.
He can't hear us because of.
You can see me?
Okay. Yes. Yeah.
Okay.
Bonolo, we can
Yeah.
hear and see you.
Yes, I can hear you. But I don't know whether you can see me.
We can see you very clearly. I confirm that we can see you.
I hear you. Yeah.
All right, that's good. Let me then try and share my screen that side. You can approve so that you can see my presentation. All right, whilst we're waiting for let me know if the screen is fine that side.
I think you have not shared your screen yet, Bonolo. You can
I
just
sent,
click share screen
I sent-
icon, bottom of the Zoom meeting.
I sent a request. Did you approve?
So it's on the other one.
It's still sport, I can tell you that.
Oh, Jesus. Okay. Whilst we are sorting this out, I'll be presenting on the Pitseng case in relation to burial rights and indigenous belonging. Yes, I think it's fine. In relation to burial rights and indigenous belonging.
Feel free to now share your screen again. Now it should work. I kicked myself out. bit difficult to operate two devices here, but now we're golden. Okay.
There we go.
Yes, there we go. That's perfect.
Right. So, like the presentation, as you said, it's in relation to indigenous belonging and burial rights, obviously in the context of Botswana. And I don't think I need to spend a lot of time here. This is a topic that we have congregated to ponder over and to deal with. But what I found interesting when I delved deeper into the concept of belonging is the understanding that maybe we need to make a distinction between belonging as per an individual, maybe feeling or psychological need, and then belonging in relation to interest, in relation to state, in the sense that you'd want to be at a particular place, welcomed at a particular place, and maybe understood at a certain level to belong to that particular location. And then studies also have spoken to the concept of belonging to say that it is influenced by various factors, daily lives, events, as well as stressors, and obviously influenced by law. And that is why we are concerned with and preoccupied with the concept of belonging in the context of law. And if you talk about indigenous belonging, obviously, there's a lot of literature that is coming out of Australia in relation to in indigeneity, indigenous belonging, as well as Aboriginal peoples in Australia, where they are saying that belonging is understood as largely, among other things, a relationship to country, and obviously a relationship to land, and a relationship to people or communities, among other things. Botswana, as you know, is one of the countries that have grappled with the issue of indigenous communities. We have a weird policy that says that we don't consider any person to be coming from an indigenous group. The policy in Botswana is that everyone is indigenous. So they don't subscribe to the understanding that they could be, as understood internationally and at the African Commission or African Union level, that we have indigenous communities. There's a speaker earlier who captured the essence of the country's position clearly. She indicated that Botswana is saying, why should we afford other members of the community more protection than others? And they are arguing that it is unnecessary to do so. This is despite that, as captured here, Basara are struggling over land and resource rights. They are being relocated, forced out of their homes because of the argument that they want to empower them, in the process trying to modernize them, which always backfires because we continue to have issues relating to poverty, land dispossession, and so forth. Now, in that context, in the context of belonging, indigenous communities in general, and specifically Basara in Botswana, and the country's position and policy and posture towards indigenous communities and indigenous rights, then comes Lesiame Vice Pitseng against the Attorney General of Botswana and others, the case. But before we get to the case, the context is that this started way before this case came along, which proves that issues of indigenous rights and indigenous communities and their marginalization are forever incremental. They don't start today and end today. They always start from long time back. It started with the Sasana case. I'm sure most of you have heard about it, relating to the relocation, forceful relocation from the CKGR, because the High Court held that the relocation was forceful. The argument then by the government was that they are trying to make way for wildlife in the Central Kalahari Game Reserve, where the Baswara were residing. They were saying that the policy did not allow for the coexistence of human and wildlife. Therefore, there was need to relocate the Baswara from the CKGR. Baswara resisted. The government then said, we are going to cut out all essential services that they were providing. Remember, the Central Kalahari Game Reserve is in a remote area, far from schools, far from health facilities, no running water, electricity, etc. And the government said, we are going to withdraw these services, ultimately forcing some Basara to move from the CKGR to where services were. But the High Court said the withdrawal of those services was unlawful, to the extent that one of the justices, in her dissenting opinion, Justice Dow said, no, that is tantamount to withdrawing life saving and life supporting essentials. But in the end, the court said the relocation was forceful. However, only those who came to court are entitled to enjoy the judgment or the outcome of the judgment. Then those who went back after the case, the court then said, but the government is under no obligation to provide essential services in the CKGR. You can go back there, but just know that you are on your own. Then comes Matsipane. They wanted to sink a borehole at their own expense. The court refused, but the Court of Appeal approved the decision on the basis that it was contrary to the right to life to prevent them from sinking the borehole at their own expense, because water, etc., it's important. Now, Lesiame was one of those who left the CKGR to stay in the new areas that were earmarked for the relocation. And he was staying in that settlement at the time that he passed. And then his son decided, and his family, that they wanted to bury him in the CKGR, where he originates from, but had to leave because of the circumstances surrounding the CKGR Sasana case. And when they tried to bury him, asked for permission to bury him in the CKGR, the court then, the government then refused and said that he's not supposed to be buried in the CKGR, one, because he was no longer resident in the CKGR, as well as the fact that they still maintained their posture with respect to conservation and a coexistence with human life. Pitseng died in December 2021. His son approached the court, and by April 2021, his bid to have an order compelling government to give him permission to bury his father in the CKGR was refused. He went to the Court of Appeal in December 2022. The Court of Appeal denied his appeal. It was refused, but the son refused to bury his father elsewhere other than in the CKGR. So from 2021 up to 2024, Pitseng was in the mortuary. We understand that the costs were so high, and the owner of the mortuary was even wondering what he's going to do with the body of Pitseng. Fun fact, President Boko, our current president, was the advocate in the case, representing Pitsi at the time. So he lost as advocate Boko at the Court of Appeal in December 2022. And as fate will have it, President Boko, then advocate Boko, became the president of the Republic of Botswana in October 2024. And immediately he stepped in, he announced that the government has taken a decision that they are going to bury Pitsi on International Human Rights Day, 10 December 2024, in the CKGR, which to him was a symbol of the new government's commitment to human rights. Remember, the previous government had been in power since 1966. And for the first time in the history of Botswana, we changed government in October 2024, which then President Boko said, we are going to bury Pitsi in his home in the CKGR. And there is the helicopter when Pitsi's body arrived in the CKGR. Remember that the CKGR is remote. The roads are very tough for people to travel to the CKGR, explaining why the state then spent a lot of resources. So Pitsi died in December 2021, and he was buried in the CKGR in 2024. And all the arguments that obviously you can think of that I alluded to earlier were at play. Key amongst those were the statutory restrictions on the Central Kalahari Game Reserve use, to the extent that they were arguing that you cannot use the reserve for that purpose, and therefore also you cannot enjoy the rights because Pitsi was not among the litigants in the Sasana case, so he had no right to reside in the Central Kalahari Game Reserve. And this was obviously in denial or in neglect of the issue of ancestral land, identity, and spirituality, belonging. The son, however, refused to bury his father for nearly 3 years in protest, despite the threat of contempt, because the Court of Appeal had said he should do so. And that reminds me of Mantua when she staged her naked protest. Of course, international law protects spiritual connection to land and burial rights. We all know these beautiful judgments, but national law does the opposite. Our position is that our policies on indigeneity are in total contrast to the position in the international realm, which obviously, I may say that when you look at the Sasana case and the Pitseng case, there's no reference whatsoever to issues of belonging in any shape or form whatsoever. There isn't even a consideration of the rights per se, and that is why they were arguing that a corpse has no rights or entitlements. Hence, they could not extend the arguments that ordinarily you would with respect to indigenous rights. I don't have to go much into this except to say indigenous belonging is understood and generally accepted. Burial rights are central to dignity, identity, and belonging. Then what I struggled with and what I'm struggling with is trying to make belonging tangible. Because when you speak about belonging, most of the time we understand it to be largely about identifying and mostly about feelings. So I think what we also need to struggle with and to grapple with in our conversations going forward, and I don't have the answer now as I conclude this presentation, is the fact that how do we then make belonging tangible? Swanson is one of the authors that I came across when he speaks to a concrete and localized sense of being at home. But beyond a localized sense of being at home, beyond a feeling of being part of a place, or a feeling that is both conscious and affectional, is there anyhow we can try and concretize or make belonging tangible to the extent that we should be able to apply it to the law without necessarily using the rights language, maybe because most countries, especially now if we apply the case of Botswana, they are adverse to the idea of using indigenous rights and under international law, maybe to advance belonging. So that is where I have stopped to say, let's think about how do we make belonging tangible to the extent that we should then be able to apply it to cases such as Vince's case, Vice's case, to have better outcomes. Thank you so much.
So I think all of the speakers have raised a lot of interesting points and questions and food for thought. So we have 25 minutes. We are very comfortable for a coffee break, and I will see to this. Questions, comments, discussion, please let me know. Yeah, you first can just start off, and I hope more come forward during your question.
Thank you. My name is Sanya, and I have a quick question for the whole panelists about the idea of customary-based law and human right-based law, because they speak a lot about that. So in which conditions a law is human right-based, and in which condition the law is customary-based? What makes it human and what makes it customary?
I don't know who of you wants to speak first. I think it kind of addresses all of your talks.
You take a few more questions.
Yeah. I don't know. Should we collect from the beginning or should we start?
Number 3.
Okay, we collect. Okay.
Yeah, thank you. I think I deserve right of reply because I was mentioned adversely by Professor Lea. I think when it comes to the issue of polygamy, my observation which could be wrong is that animals, which humans are part of, have an inclination to be a bit polygamous. It's maybe either serial or simultaneous. But let me speak for Africa. From the observation of our relations and our belonging on our spaces. I think if you look at most of our customary rules in most African societies, you'll see an element that allowed and supported polygamy. You just mentioned that in some communities in South Africa, the rule was that you ask consent from the first wife to marry others. That's in the customary rules. Within some communities in Kenya, for instance, they had this rule that allowed actually your age mates to sleep with your wife. They could just come and plant a spear outside your home, and that spear indicates that that person is going to sleep in that wife's house that day. And as a tradition, you could not stop them because then you'll be an author, you will not belong. This is the rule, that is the way we operate. So I think if you look at so many of our society, the way it was organized, we have all these cases that this was our way of life. And maybe that's why I mentioned that. Not just Kenya, but that we tend to be a little bit more polygamous. But then the law came because the monogamy, mostly in Africa, was introduced as a legal concept, looking at our rules. So the law came and it was introduced to us, and it was, remember that case of Colbert versus Colbert. One man, one woman. And then we started struggling. If you look, for instance, in Kenya, we have struggled so much to move to fit within this monogamy law. So for a long time, Kenya had this law, that Marriage Act, that did not recognize customary marriages. It was civil and all those other ones which are formal. But then, because we still needed to protect our other customary arrangements, we had a law of succession that was polygamous. So you can be monogamous when you are alive, but polygamous when you are dead. Yes, the law of succession accommodated wives, and it had wives. And so we have continued amending. You realize at any particular time we don't have a streamlined succession and marriage law that is purely monogamous. So eventually in 2014 we said in Kenya, why are we struggling? Let's just have polygamy as a proper, recognized legal marriage with no requirement. Just choose whatever you want to do in your own, between the parties as your customary practice. Then come and register it, even if you register 20 people. So, so in this case, I would say that on that case of the courts converting consent to converting asking, just informing and asking to consent is a proper case of where law and the institutions that enforce law are hijacking. It's actually where we find that subserving, sorry, the term has disappeared. The property subject who are already recognized are being removed. Professor says I stop.
We'll talk about this in other more suitable fora, but I would like us to give more space for other questions. Thanks for this reply, by the way. But are there any more questions for the panel?
Yes, please.
Okay.
So, my fellow PhD club member, I really like the idea that you floated regarding Ubuntu. So it's something that has featured in so many research, even in energy research, energy scholarship, as well as environmental scholarship. But oftentimes, when people talk about it, it seems as if it's been used to address future injustices that will occur, in this case, with respect to the environment. And so I wonder whether you've thought about whether there are opportunities for it to be used to address past injustices, or maybe you could say reparations, and whether it does create opportunity where you could incorporate the ideas of, by way of addressing past injustices and also thinking about reparations. Is this something that you think Ubuntu can also do in that regard?
Should we collect another question, or should we answer maybe in between? Good. We take your question and then we go for the answers. Okay.
It's a very short question on the question of Ubuntu. Isn't Ubuntu fundamentally opposed or contrary to the idea of environmental law? Because of course Ubuntu is concerned with Mother Earth as a being, not something called the right to the environment that needs to be protected by human beings. In Ecuador and Bolivia, they talk about Pachamama. The idea of Pachamama very different from the idea of environmental law. So the integration of Ubuntu into environmental law isn't that the domestication, assimilation, and therefore the misuse of Ubuntu? So the framework is still Eurocentric, something called environmental law. We are just adding the spice of Ubuntu into this Western dish. Thank you.
Yeah, I think so you have 15 minutes to answer those questions, but maybe we shorter and we can have more questions. I don't know who wants to start.
I can start by way of background. I think when you think of customary law, although I don't like that expression, custom is better. But it's a quite powerful, it's a very powerful grip, as we saw yesterday during the screening, because this is a web of shared understanding to which people have a very strong attachment, and actually they interact based on that shared sense of understanding. It has a very strong grip, actually, to the extent that it is perhaps state-driven law as more or less not helping them. So they are willing to put up resistance, like the lady we saw in the movie yesterday did, just to make a point that, look, when it comes to normative frameworks, we don't really need the external help. We are fine in our relation to ourselves and the wider non-material world, which in a sense begins to tie on what has been raised, but I'll not go deeper because I have my own views on that, which are not part of what I've presented here. So perhaps I will hand over to Professor Lea here.
Okay. Thank you. So on the distinction between customary law-based human rights and human rights-based law. So there the distinction with human rights-based law comes from international human rights standards, whilst as the other one comes from the customs and our practices.
Right.
Yeah.
You want to ask something?
You want to?
But what makes it international, since other parts of the world are not part of this creation of the international, because they're speaking also about customary as international.
What makes it, so the human rights-based law is derives from the international human rights system. So that's what makes it international.
Yeah, who is in display of international constructivist of international law? You just think about it and
Maybe anybody can jump in.
International lawyers.
I'll answer that later.
Okay.
Okay.
Richard.
Okay, so on what Monica touched on the issue of polygyny and the issue of the case where the Constitutional Court in South Africa held that the customary rule of the first wife being informed was developed to now requiring the first wife to give consent before a husband can marry a subsequent wife. To me, it is one of the kind of clawback. You recognize the institution of polygyny, but then you put in clawback limitations to the practice of that, because from the men here or from the women here, who is going to give consent for the husband to get married to the second wife? Coming to the issue of the Kenyan Law of Succession Act allowing polygynous marriages after death, in South Africa with the Reform of Succession Act, we see that there is protection to women who would be in the sororate union, like the supporting role when the wife is barren, she can't have children. So they enter into these unions where a sister or a niece to the wife would enter into a relationship and a union for the objective of having a child for that marriage. So those women, because they were supporting role, and remember with a customary marriage, it's a union between two families as opposed to two individuals. It's not a marriage, and in the Reform of Succession Act, so the Recognition of Customary Marriages Act does not recognize those unions as marriages, whilst as the Reform of Succession Act seem to give protection to those women to benefit from the deceased husband's estate as if they are spouses. So there's kind of a similar approach in the protection of those women. I think that will be the questions.
Yeah.
Yeah, thank you for the question. I don't have a concrete answer, but this is an opportunity for further discussion. So for the reparation perspective, yes, Ubuntu can help to reconcile past injustices and reinitiate harmony between human beings and non-human beings, and especially in mining frameworks, the conservation or the reparation of environment as the mining activities take place is also another form of reparation. And to Ubuntu being in contradiction with environmental law, my perspective or my position will not be no, because it helps first to acknowledge that nature is part of our human world life. We are connected with nature, and therefore activities which are taking place in the environment, or let's say in this particular case, mineral resources extraction, should take into account that nature is part of our human ecosystem. And as we've seen in the movie yesterday, it's also a source of life. So we are connected to it. And then by drawing on Ubuntu principles, it helps us to reframe or to bring back principles of connection, relationship between human beings and non-human beings to create that harmony between living and non-living environment. But I would like also to hear more about your perspectives.
Okay, Bonolo, do you have any answers for us or any thoughts for us?
No, I don't have any contribution.
All right, any more questions, comments? Yeah.
I have something for Bonolo.
Yeah,
If that agree.
Of course.
And I must say, I'm not a lawyer, so I'm really learning a lot here. I come from the management scholarship field, so I was reflecting on the question you posed in the end, that how do we make belonging tangible? And as I was thinking and reflecting, in organization studies, which is something I focus on, we often use the idea of sense making. And sense making is essentially, anyone trying to interpret an ambiguous or an uncertain situation to arrive at some kind of meaning. And I thought that had some resonance with Professor Kambili, what you said about legal consciousness, where people experience, understand, and there's an interpretation, but there's also an element of action. So I feel one way to make belonging tangible is to look at what action it leads to, or what is the intentionality in that belongingness, or the feeling of belonging that leads to a certain action. But I still think it's not a straightforward concept. I think belonging will always be more at the feeling level, and that's how I interpret it, that's how I understand it. But one way to give it some structure would be to look at what action it leads to. So that's what came to my mind, and I thought I'd just put it out there.
Well, thank you. Please, there were yeah.
Yes, and I have a question. I think just reflecting on Lea's presentation, Prof. You mentioned something which I think was connected to what Ange Dorine has spoken about. So it's about the fact that laws can also come with them with baggages that might need to be shed off. But when you want to transition to mediate between human rights considerations and also the custom, this mediation will warrant some sort of transition, because in your presentation, you mentioned that there's need for some community-driven change. So you envisage some form of transition, and now it is this transition which I would like to direct my question to. What happens at the transition stage? We have these instances where what was a cultural practice tonight becomes an illegal practice the next day, just because there's a new law that has come into force, for instance. In your proposal, you propose this very participatory process of changing things, because for sure, there are certain practices which are considered as custom, but maybe there's need for mediation so that even the people themselves their consciousness can be raised, so that they appreciate that at least this is a practice that they need to depart from. But what happens in the transition? Should it be abrupt, as Prof mentioned yesterday in the opening speech, or what happens in this transition? Because I envision that even the transition itself should also be a just process. So maybe you can comment a little bit on this as part of what you thought about it when you are making the suggestion for community-driven change.
Okay, thank you. I think we have time. Yes, Coco, of course.
Yes, okay. Prof. Bonolo, we've been debating about this topic for a while, and these cases that you highlight somehow show the limitations of the common law and common lawyers in the way we imagine worlds. So these cases are actually being dealt with as property cases. And yet, I think there's more to how we imagine our connections to land, to soil, and everything that's on it. That can't be captured by the limited conception that is available in the common law and the statutory law that backs it. And so perhaps to nudge you a little bit to speculate a bit more about the possibilities that we have in our constitutions. We have nice sounding imaginations of how we could be. But as a matter of ensuring belonging and therefore changing the way we imagine property law and interests in land and interests in the environment that we inhabit and that keeps us. I mean, what are the possibilities there? So a large question, but it's connected to this disjoint that maybe not disjoint, but discomfort that we have in talking about feelings when we are talking about law, you know, because the law somehow is assumed to be objective and is meant to be objective. In the morning, when Carsten was here, said, yeah, but maybe if you replace law with politics, then this would be the answer. But for me, law is politics. There's no special category of that. Law just happens to be a subset of politics done in a particular way. Okay, but I'll leave this to you. And with Ange, I like the way you are interrogating this idea of management of our resources and trying to make these connections between the animate and inanimate, something that the law is still struggling to grasp. And that's why it's possible for us to do what we do with nature and the environment. And there is possibilities that are opened up by deploying these understandings of Ubuntu. Tshepo, I hear you, but I think that there are doors that are interesting that can be opened by doing this. And to perhaps piggyback on Tshepo's perspective, what are you trying to do? Are you trying to add salt to this debate, or this is a new dish that you are preparing? And then to Cyprian, finally, I'm with you that one cannot assume transformation after legal change. But what are the preconditions that you would elucidate if we are to have this relational legal consciousness? Okay, that's it.
So, quick round of answers, and I would say we start with Professor Bonolo, and then go all the way back, and then have coffee. Okay.
Okay. Thank you so much for the comments. I'll look into the sense making paradigm to try and see how we can reduce the belonging from the level of feeling to something tangible. And Prof, I'm thinking that when we are taught in law school, we are taught that we should be dispassionate as much as we can in handling cases and in resolving disputes. That explains the decision possibly in the Pitseng case that everyone could see that it is wrong. I'm sure even the judges, as they rendered their judgments, they could see that to deny someone to be buried where they were born, raised, it is wrong. But the law said that is what should happen, perhaps in their thinking. And yes, I'll speculate on what the possibilities, but essentially we are trying to go back to where we were before we received these laws. To me, it seems so obvious that I wonder whether that would work, because if we were then, obviously Pitseng wouldn't have these issues, because then under our customary laws, under our customary practices, he would be considered to be entitled to be buried where he was born. So as much as we think that law should have feelings, but the truth of the matter is that the future seems to suggest that law should not have feelings, and that is why we have decisions like this. So we go back and maybe in our constitution constitutionalize customary law in a manner that would perhaps speak to these issues better. Thank you so much.
Yeah. In my perspective, I'm trying to use Ubuntu principle to complement legal rights and duties in environmental law, and also to bring the collective responsibility in limitations that already exist in environmental laws. Thank you.
Okay, so to answer your question, community-driven change. The assumption that is mostly made is that there are no customary remedies to address some of the human rights violations that comes with certain practices. So the engagement with the community is to have, and also the different customary practices have a cultural significance, which is not known by this top-down approach. But if you engage with the community, you get to understand the cultural significance and the cultural remedies that are available there, and work through that in how to best address what the current violations, considering also that the customary law is dynamic. So what is law now is not going to be law in 10 years. It's going to change by the communities themselves.
Yeah, I think from both the output brain about transformation, change with transformation. I think from the perspective of legal consciousness, there are perhaps three aspects. One is the worldviews, that this particular legal consciousness is not uniform for everyone. It's socially constructed, individually, but also collectively. So in terms of relational legal consciousness, the change has to be meaningful from the worldview and the perception of the intersubjective legal actor, so that from this worldview and perception, they probably can make a decision that makes sense from what has been provided in the framework. To give a quick example, cultural rights. Most of the constitutions that I've come across are very broad. They're just trying to get it over with. But if they properly defined, to say the right to culture ABCDE, that ABCD has to reflect in the worldview and perception and decision making of these interactive subjects in a way that either reinforces or supports their identity, and definitely does not make it impossible for them to express themselves or to interact or act vis-a-vis other subjects. I don't know, because I'm talking at a broader abstract level, not within a specific context, if that makes any sense.
Okay, so I'm sure there are more questions, but there's coffee outside. So I would suggest that we all move outside and pose the questions individually. Thank you again to all the speakers. Thank you.
To have the keynote this evening on citizenship and the state. And I think each of the papers that we'll hear on this panel this afternoon interrogate how law, particularly its relations to the state, constructs and contests the boundaries of belonging. You know, and for the sociologists and anthropologists among us, we might see citizenship as something that's negotiated, that's fluid, whereas legal scholars might have a more fixed understanding of this construct. And I think we're going to push the boundaries of this particular tension across different cases, across different geographies. You know, something that's remade and made every day through everyday practices, through exclusions to resistances. So from Germany's radicalized citizenship law to the efforts to constitute belonging in South Africa, from the long shadows of the global far right across Africa to the endurance of refugees in Tanzania, these papers collectively ask who belongs, who decides, and on what terms. So each of our panelists will have about 15 minutes. I'll give you a sign when you have 5 minutes left. And then I hope we can have an enjoyable discussion afterwards. We'll start with Merle Iffert. She's a research associate and doctoral candidate at the chair of criminal law and criminal procedural law, international criminal law and legal contemporary history at Humboldt-Universität Berlin. The topic of her doctoral project is kritische Kolonialstrafrechtsgeschichte, loosely translated in English as German colonial criminal law from a critical perspective. A research focused on critical legal theories, as well as criminal law, particularly modern German criminal law history, international criminal law, and international. So without further ado, you have the floor. Yeah, thank you very much.
Thank you so much for the kind introduction, and also to Professor Toko and the entire team for organizing this conference. In my presentation, which is partially based on the paper I co-authored last year, I would like to give an introduction to racist exclusions in German citizenship law. Citizenship law is probably one of the most exemplary areas of law that regard the question of belonging. In my presentation, I will argue that the legal concept of what it means to be German is shaped by racist notions, making belonging and exclusion two sides of the same coin. As far as law is concerned, the regulation of citizenship shapes a nation's identity. Citizenship law defines the necessary criteria for being accepted as a fully fledged member of society, thereby setting a minimum standard of, in this case, German identity. Being a citizen of a country one resides in holds many privileges that not only pertain to the right to vote, but also everyday life, such as passport controls, entering into marriages, or opening bank accounts. As a result, those not afforded these privileges are constantly marked as the other, with the right to existence in this country being regularly called into question. Citizenship law has consistently fulfilled this function of inclusion and exclusion in the past as well as in the present. In the first part of my presentation, I will give an insight into how citizenship law was used in German history to oppress certain people and privilege others. For this, I have chosen to focus on the role of citizenship law during German colonial rule to privilege white settlers and discriminate against colonized people. Given the time restrictions, I will not delve into how citizenship and its withdrawal were used under National Socialism, especially to persecute Jewish people, although I do want to note that this is an important part of research on belonging and exclusion in German citizenship law. Secondly, I will focus on the most recent reform of German citizenship law that was passed last year and question its widely acclaimed progressiveness. Thirdly, I will give an outlook on the new government's way forward, or more accurately, backwards, for the next 4 years. To start off, I will not give an overview of German colonial history, but simply note that the German Empire colonized several territories on the African continent, in China, and several Pacific islands between 1884 and 1919. In these territories, the German colonizers established a dual legal system that racially segregated white people from colonized people. The privileged status group was synonymously described as white, European, or non-native, and consisted mainly of German citizens and members of so-called other civilized nations. Everyone else was categorized as so-called Eingeborene, which is a term that, due to its racist connotation, does not properly translate to the English native. The applicable law and competent courts differed considerably depending on which of these two status groups one belonged to. If one only looks at the colonial legal system from a strictly formal and very superficial viewpoint, one could argue that the privilege was not determined by race, but by citizenship. This viewpoint, however, would neglect the obvious intersections of race and citizenship in the colonial setting. Instead, I will argue that German colonizers deliberately chose to make citizenship of a so-called civilized state a necessary requirement or relevant criterion for whiteness, since such a citizenship predominantly coincided with whiteness. This becomes evident when one looks at how German citizenship law was adapted in the colonial context. In the citizenship law of the time, citizenship was generally acquired through birth. Nevertheless, there were differentiations due to the patriarchal character of the law. If a German woman gave birth out of wedlock, her child was German. However, a child born to a married woman shared the husband's nationality, so the child would be German if the husband was German. Through marriage to a German man, a woman automatically became German and usually lost her previous citizenship. This mechanism was based on the concept that core families should all share the same citizenship. In the patriarchal German system, the man was considered the head of the family who decided the citizenship of the entire family. As a consequence of this nonsensical concept, German women also lost their German citizenship if they married a non-German man. All of these automatic mechanisms became relevant in the colonial setting. Colonized women who married German men acquired German citizenship, and so did children that resulted from this relationship. This, in turn, threatened the racially segregated colonial legal system that was based on the ideology of white supremacy. As time went on, colonial officials, especially in present-day Namibia, prevented German men and colonized women from entering into legally accepted marriages, so that the women and children resulting from these relationships would not become German citizens and thereby also not legally white. German women, on the other hand, lost their German citizenship if they married a colonized man and became stateless. So technically, they should have been grouped into the status group that was called Eingeborene. However, some argued that they should still be considered legally white despite their statelessness. Others, however, found it corresponded with the so-called national self-respect if these women were subjugated to the discriminated status group. After all, the role of white women was limited to serving white men as housewives and preserving the white racial honor, a duty that violated by marrying colonized men. For colonized people in general, the only way to obtain German citizenship was through naturalization. The relevant regulation stated that the applicant must not have prior convictions and be equipped with sufficient financial means and accommodation. The regulation did not provide a right to naturalization. Instead, it left the decision to the discretion of the German chancellor. This discretion was used in the colonial context to systematically deny the naturalization to almost every Black, Indigenous, and person of color who applied. Racist arguments were brought forward to justify this discriminatory practice. Colonized people were, as colonizers claimed, still at such a low cultural level that their naturalization was not appropriate. Not only did German colonizers prevent colonized people from attaining German citizenship, they also protected German citizens from losing it. The law included a provision that stated that German citizens lost their citizenship if they resided abroad for more than 10 years. As an incentive for German settlers to move to and stay in the colonies, the German parliament passed a law that declared this provision inapplicable in the colonies. Overall, German colonizers endeavored to keep the group of German citizens as wide as possible, which proves my point that citizenship and race were inextricably linked in the colonial setting. The German legislator reformed the citizenship law in 1913, so shortly before the end of the German colonial rule, without changing anything substantively. This law is still in force now, although it has since been reformed quite a few times. This leads me to the second part of my presentation, the current legal framework. Just like during colonial times, German citizenship is still mainly acquired through birth. The German legislator has given up the patriarchal regulation that centers the man's citizenship. Nowadays, for a child to obtain German citizenship, it suffices if one of the parents is a German citizen, regardless of marriage status or gender. However, it is more difficult if the couple is unmarried and only the father is German. This has proven to be a gateway for German authorities to reject claims, especially from West African women, to recognize the German citizenship of children they have had with the German men. Regarding naturalization, the German citizenship law nowadays includes the right to naturalization. However, the regulation that guarantees this right stipulates a plethora of requirements. The reform last year by the now still caretaker, rather progressive German government did not reduce the number of requirements, but merely changed some of them. It remains necessary that applicants, for instance, can prove their identity and current citizenship, that they do not have criminal convictions above a certain threshold, that they have sufficient knowledge of the German language, the legal and social order, and the way of living here, that they accept and respect the German constitution, and that they are already in possession of a certain type of residence permit. Commendable modifications through the reform include the permissibility of dual and plural citizenship, which was formerly only limited to certain nationalities. Also, applications can now be submitted after 5 instead of previously 8 years of legal residence. The period of prior residence can now be reduced to 3 years at the discretion of the authorities for applicants who are considered especially well integrated. As part of the reform, the legislature also abolished the vague requirement of integration into German living conditions and replaced it with 2 new but no less problematic prerequisites. Firstly, the applicant must not have committed anti-Semitic, racist, or other inhumane acts. Secondly, the applicant must not be married to more than one spouse and/or show through their behavior that they violate the constitutionally guaranteed equality between men and women. In the explanatory memorandum to the law, the government made it clear that this latter paragraph targeted Muslims. The example given for potential evidence in such cases was and I quote, fundamentalist understanding of culture and values, according to which Sharia norms are superior to the German legal system and women have an inferior legal status. With this statement, the government assigned patriarchal claims of ownership over women exclusively to cultures influenced by Islam, thereby externalizing them from German society. Furthermore, framing polygamy as an anti-modern concept that is irreconcilable with women's rights and therefore apparently German identity is an obvious continuation of colonial narratives, unacceptable relationship models that were and are influenced by Christian concepts of morality. However, the German government's claim to protect women is not credible. After all, part of the reform was to restrict the accessibility of citizenship for recipients of social benefits, making it nearly impossible for them to acquire German citizenship. This especially affects women in precarious positions, such as single mothers or women with care responsibilities, as well as people with disabilities. In the end, what is left of the protection of women in this reform is its usefulness as a legal policy argument that can be instrumentalized in a racist way, while at the same time excluding mostly women with lesser financial means from German citizenship. All in all, patriarchal and racist notions in citizenship law may have become less obvious compared to now over a century ago, but they are still alive and well. So while the reform did include a few improvements, it is not as progressive as was claimed. Yet the Conservative Party, which was in opposition last year, argued the German citizenship had been devalued due to its alleged broader accessibility after the reform. This brings me to my last point, an outlook on the new government's plans concerning citizenship law. Today, the new Chancellor, Friedrich Merz, who is a member of the Conservative Party, was supposed to be sworn into office. However, he is the first candidate in the history of the German Republic to not have received sufficient votes in the first election. So I think right now at the moment, they're doing the second round of elections, so let's see if he will be sworn in today. I did not expect it when I wrote my presentation yesterday, but so that's why I'm already saying new government, although the government is not actually the new government yet. Yes, okay. During the election campaign, the Conservative Party suggested reforms of the citizenship law, which was part of a broader and racist anti-migrant agenda. Their demands included abolishing parts of the reform from last year. Merz, in particular, suggested that Germans with dual or plural citizenship should face withdrawal of their citizenship if they were criminally convicted, thereby rendering them second-class citizens. This demand was met with resistance due to its unconstitutionality and was not included in the coalition agreement between the Conservative and the Social Democratic Party. However, the Conservative Party prevailed over the Social Democratic Party in one aspect. They agreed to abolish the possibility of an accelerated naturalization for so-called especially well-integrated foreigners. Besides this step backward, the Social Democratic Party seems to have been able to safeguard the remaining aspects of the reform for the time being. Considering the tangible shift towards the political right, prospects for progressive reforms in the foreseeable future are bleak, to say the least. This brings me to my conclusion. As I have demonstrated for the historical and current context, citizenship law mirrors societal and political debates on what defines German identity and who is worthy of the privileges that accompany it. Belonging and exclusion are pawns that can be shifted according to political expediency. During colonial rule, German citizenship law was characterized by patriarchal and racist notions that only deemed white men as subjects truly worthy of German citizenship. While improvements have been made since then, such notions still influence German citizenship law. They may change their shape according to the political context and become less obvious, but they remain embedded in the legal framework. To echo the wording of the Conservative Party, if such a thing as a devaluation of citizenship exists, this threat is not based on its increased accessibility, but rather on persistent racist and patriarchal mechanisms of exclusion. Thank you for your attention.
Thank you very much. We'll do a Q&A afterwards. Next up, we have Commissioner Tshepo Madlingozi, who studied law and sociology in South Africa, Cameroon, and the UK. He's currently a commissioner of the South African Human Rights Commission. Prior to that, he was an associate professor and director of the Center of Applied Legal Studies at Wits University, teaching human rights and social justice. The biography is quite long, but we've agreed to leave it at those distances.
Thank you, and good afternoon. It's a pleasure to be here. Thank you, Josephine, Samwati, Isabel, Gift, Ari, and for, of course, my friend, Professor Toko. I was counting how long we've known each other. It's exactly 23 years now. We were kids when we met, essentially. So really, it's an honor to be here. It's a full second moment, to be discussing the theme of your center. And congratulations on your 5th year anniversary of the center, and may it, go from strength to strength, the center and the chair, but also discussing how our two projects. So last month at the Human Rights Commission, my office launched a campaign called Promoting a Culture of Human Rights through the Resolution of the National Question. Promoting a culture of human rights through the resolution of the national question. Now you might ask ourselves, why is there need to talk about the national question in South Africa 30 years into democracy? This year also marks 30 years since the establishment of the Truth and Reconciliation Commission. This year is the 30th anniversary. And of course, South Africa is the poster child of transitional justice, the poster child of healing, nation building, reconciliation. All of them, of course, are lies. Not necessarily myths, but they are lies. There is no nation building, there is no reconciliation, there is no coexistence in South Africa. I come from a country without a name, simply called South Africa. It's only one of 3 countries in Africa without a name. You know the other 2?
Central African Republic.
Central African Republic.
Western Sahara.
And Western Sahara, of course. What does it mean to come from a country without a name given to it by the settler colonialist? It's a country that epistemologically, culturally, psychically, aesthetically thinks of itself as a province of Europe. A country that is uncomfortable with its African location. We still think maybe we should be next to Portugal somewhere. The most xenophobic country in Africa, black on black violence. So you will see that the theme of this talk, and I'll only talk for 10 minutes because I'm going to be talking tomorrow and I'm going to be talking on the 9th, so I don't want to take too much time, and also I just arrived today, so I'm a bit tired. The theme of my talk is the ongoing strivings for constitution and belonging in South Africa. In 1916, about 110 years ago, a writer wrote a book called Native Life in South Africa, Native Life in South Africa. And he begins that book with a phrase, awakening on Monday, August 1913, the South African native woke up to find themselves not a slave, but a pariah in the land of their birth. Not a slave, but a pariah in the land of their death. That was of their birth. That was in 110 years ago, 1916. I want to argue that this condition of native pariahdom continues in South Africa, that Black people still continue to experience a condition of native pariahdom. And I will argue that this condition is because of a failure of the project of decolonization. Democratization without decolonization. Democratization without decolonization. That's the condition in South Africa. And by decolonization, I mean the remembrance of the African social cultural world that was shattered by settler colonization. That's how we should understand decolonization, the condition of remembering. By remembering, I mean to remember, recall, but also remember, remember the worlds that were shattered by settler colonialism. That's why you can have democratization without decolonization. By constitution, I don't mean a legal document. By constitution, I mean the etymology of constitution, which is customary, which means to stand together, In my language, constitution is more lautero. a foundation to found something. So when I talk about the failure of constitution in South Africa, I mean the failure of constituting a world of togetherness. That's what constitution means in this case. And belongingness, and the failure of belongingness is a symptom of this fundamental failure to constitute a proper post-colonial South Africa. It is a failure that I call, that is caused by a paradox, a fundamental paradox in South Africa. And this is a paradox that I call constitutionalism without constitution. A paradox that I call constitutionalism without, so South Africa has got one of the best constitutions in the world, in the sense that it's got a lot of rights, vertical accountability of the state, so constitutionalism is there. But constitutionalism without constitution, that's a paradox in South Africa. And it's also a failure of to instantiate a paradox that we see in settler or in post-settler constitution making. And the paradox there is a paradox of deconstitution and reconstitution at the same time. To have a proper post-colonial society, there needs to be a deconstitution and a reconstitution. In South Africa, with a reconstitution without deconstitution. The result is the assimilation of Black people into the exact world created by the settlers. The integration of Black people into the world created by the settlers. Assimilation. Because of a failure to deconstitute. And this failure has led to a failure of post-colonial we-ness, the failure to constitute a post-colonial we-ness, togetherness. And it's a failure that can be seen in what I refer to as the 5 crises of constitution in South Africa. The 5 crises of constitution. The first crisis is a crisis of ongoing Black dehumanization. The first crisis is a crisis of ongoing Black dehumanization. As you know, South Africa is the most unequal country in the world. Black people poorer than they were during apartheid today. But not only that, Black life continues to be cheap in South Africa. So every year, you hear incidents of a lot of Black people dying. I don't mean 50, I mean 100, 200 in a single incident. But life continues as normal. Black life continues to be cheap in South Africa. So that's the first crisis. The second crisis is a crisis of renativization, the making of Black people into natives again. The crisis of renativization, the making of Black people into natives once again. Mahmoud Mamdane's got a famous book, Citizen and Subject, where he talks about the fact that in late colonial South Africa, there was a bifurcated state that was created where one part of the public are citizens who are ruled by civil law and constitution, and the other are ruled by something called customary law, a funny thing called customary law, under the leadership of chiefs and traditional leaders. That condition continues today, where about 20 million people are not beneficiaries of civil law, but they are ruled by this thing called customary law, under the leadership of chiefs and kings. So the situation of bifurcation continues, a crisis of renativization. The third crisis, of course, is a crisis of the ongoing subjugation of indigenous kingdoms, the ongoing subjugation of indigenous sovereignty. As you know, the condition of possibility of South Africa being created was the conquest of African kingdoms. the Zulu kingdom being the last one to be conquered. That became the condition of creating South Africa. That situation continues. The colonial state form continues, and the indigenous kingdoms continue to be subservient to the colonial state form. So in 1994, you had government succession, but not state succession. The state is still the colonial state form that was created in 1910, where African kingdoms continue to be subservient. The fourth crisis, of course, is the ongoing subservient nature of indigenous legalities, and therefore indigenous ways of being in the world. So something called customary law is recognized in the Constitution, but subject to the Constitution. Of course, the Constitution is not neutral. It is a Euro-modern document, the South African Constitution. It's a Euro-modern document. And the application of indigenous law is only if it conforms to this Constitution. That's why you can have customary law recognized or civil marriages, customary marriages recognized, but also not recognized at the same time, because you are judging African law according to a Euro-modern constitution. So the ongoing subjugation of African ways of being in the world. Then the last one, of course, is the ongoing crisis of settler-native relations. The settler is someone that comes to your land, takes your land, and still keeps your land. Not someone who immigrates, but someone who comes, dispossesses you of your land, and continue to hold on to it. South Africa today, white people are 8% of the population, but they own 70% of the land. 8% of the population owning 70% of the land. So ongoing settler-native relation continues. So these 5 crises of constitution have led to what we can refer to as neo-apartheid constitutionalism. Neo-apartheid constitutionalism. No longer apartheid, but not post-apartheid. A state of liminal constitutionalism. I'm using liminal in a traditional anthropological sense, as used by Van Gogh and Turner and so forth. A failure of rebirth, liminal condition. I want to have time to propose solutions. But at least in the case of South Africa, to attend to the lack of belonging without attending to what was the meaning of colonization is a mistake. The first mistake in South Africa, of course, is to make apartheid the unit of analysis. Apartheid, who cares about apartheid? We don't care about apartheid. Apartheid was only there for 48 years. Colonialism was there from 1652. The first conflict between white people and black people in South Africa was in 1510. But it is in the interest of some people to make apartheid the unit of analysis. Once you focus on apartheid, you focus on segregation and civil rights. You focus on segregation and the extension of civil rights. But once you make colonialization, not even colonialism, colonization the unit of analysis, then you are able to focus on what did colonization mean for black people in South Africa. You find this in the way that was used by black people in the 1700s. Ilizwe lifile. The world is dead. So the more conquest and land dispossession was happening, black people used to have this kind, ilizwe lifile, the world is dead. What they meant by that was that the eruption of Western modernity and settler colonization meant the shattering of the social cultural worlds of black people at the material level, the spiritual level, and the social level, the 3 levels of African belonging in the world, spiritual, material, social. The lesson from South Africa is that the crisis of belonging is a symptom of a failure to achieve this remembrance of those who are at the material level, the issue of land dispossession. You know, land in my language is lefatsi. Lefa means gift, fasi means the ground. So land is not only about identity, it's not a material being, it's about ontology, fundamentally. And the lack of land return really creates a crisis of ontology and belonging in the world. The failure to reimagine the world at the social level and also at the material level. I'll have more to say about this tomorrow and on the 9th. Thank you so much.
Thank you very much. Next, we have Professor Stefan Ouma, who's the chair of economic geography at the Department of Geography here at the University of Bayreuth. Before that, he was at the University of Frankfurt, Goethe Universität. His work has focused on rematerializing the economy, drawing on insights from heterodox economics, political ecology, and post-decolonial work. Worked on global supply chains, financialization of land and agriculture. Actually, the keyword materialization that you just mentioned is critical here. But today we're going to hear more about Africa and the shadow of the forest. So,
yeah, thank you very much for making this nice event possible. I think Toko and his team remind us that sometimes you have to celebrate what you have achieved in style. My own chair forgot this, so I passed my 5 years and nothing happened. But I think this is the way to go, and I'm happy to be here, especially in the new building. So this is kind of a new topic for me, but it's a topic you can't avoid, especially in a German context. But the far right has come to dominance in a variety of contexts and geographies, and sometimes we have really a difficult time to capture the varieties of far right rises, let's put it that way, from Bolsonaro's Brazil to Modi's India to Geert Wilders in the Netherlands and Donald Trump, of course, and many others. And because we are here in a German context, I think it's very, very important to start with this first and give you a brief crash course into a differentiation that is really important between the old right and the new right. So it's a little bit provincial in the sense that we have to return to France and Germany in the 1970s, but this is really, really important before we make the jump to Africa. So the alt-right, the old right, as some of you who are familiar with the geographies here may remember, are usually associated with alt-Nazis, leftovers of the former Nazi regime, neo-Nazis, skinheads, people who openly display an admiration for Nazi ideology, for the Third Reich, but often they were operating in a kind of parallel universe. It was very unlikely that they would ever come to power again, and much of society actually didn't like them. So they lived in their own parallel world, waiting for day X, which probably would never come. The new right is a little bit different. It emerged in the 70s in France and Germany, and if you want to boil it down to what they are for or against, it is two big figures. It is 70, 89. So all the at least on paper, the liberal values you would associate with the French Revolution and the humanism, etc., etc. And it's 1968, which represents a crucial year for feminist movements, for civil rights movements, for critical education, especially in Europe and the United States. They avoid direct Nazi references and have opted for a very smart type of discourse setting, a march through the institution, and they're convinced that you win political battles in the pre-political domain. So not through elections, that may come later, the fight starts elsewhere. And AFD is a very good example for this, and a kind of Selbstverharmlosung, make yourself appear harmless is also a key strategy. So that is a little backdrop. Keep that in mind. It doesn't apply equally to all these new far-right movements, but there are connections. And since Europe and the US are very central in those transnational developments and there are linkages between them, it's very important to keep this in mind. Let's start with Donald Trump, savior of the wars. You may have seen his latest Truth Social, not latest, but not so distant Truth Social post about South Africa, and that certain groups of people are being treated very badly by the South African government, referring to the Land Expropriation Act that was, I think, passed by the coalition government already. So the DP is already a part of the story here, and Trump came out to post this, and then he threatened to sanction South Africa and so on and so forth. Meanwhile, the South African ambassador has been expelled from the United States. It was not the first time that he came out. Already in 2018, he said, I've asked Secretary of State Pompeo, which is an enemy to Trump, to closely study the South African land and farm seizures, etc., etc. So he's clearly playing with this far-right narrative of the white genocide. And he basically picked up what Tucker Carlson, who in the meantime interviews Vladimir Putin and seems to be quite close to him. Tucker Carlson had hosted a far-right South African group, AfriForum, already in 2018 and has repeatedly done so. So Trump picked up the thread that Fox News laid. And he had powerful amplifiers. South African called Elon Musk has jumped in repeatedly. He is battling with Malema. And there's a whole bunch of South African, white tech guys who seem to have clearly moved to the dark side of Silicon Valley, and it's a connection worth investigating for its own. So this is a prelude that shows you somehow far-right developments in Africa, now represented by South Africa, but it's larger, are meeting. So how do we make sense of this? I think there are different responses you can have. First response might be the one that sounds as follows. These are white men issues, why should we care? Africans have gotten involved in white men's wars before, often with no benefit, pensions that were not paid, betrayals, erasure from history books, and so on and so forth. So the first and especially the Second World War is full of these stories. So why should we get involved? Well, Germany and their struggle with AFD and so on and so forth. A second response might be a more geopolitical response, where you say the old world order is collapsing, and African leaders and the AU would be wise to reckon this and reposition themselves accordingly, look for new partners, etc., etc. We can work with that, but I don't think this is sufficient. I would rather develop a different approach and really try to uncover the meeting ground where far-right forces from assumingly distant geographies and what happens in Africa meet quite intimately. And this is the scary thing sometimes. And I think not many people have thought about this very well, especially in a transversal sense that you try to connect these different geographies. So in the following, I'm trying to talk about 4 brief moments that I think are important, and I speak of entanglements. I think it's the most convenient term. Don't want to say connections or linkages. Entanglement leaves some sort of flexibility of how you eventually end up theorizing and researching these moments. So let's start with an uncomfortable one of appeal. Is there something in the rise of the far right and their ideologies that is appealing for actors on the African continent? And the global south more generally. So if we look at some commonalities in far right movements from Brazil to India, from the US to Germany, you see at least 4 commonalities. Far right movements support rigid social hierarchies, often naturalizing these hierarchies. Second, these inequalities are viewed as I just said, as natural rather than the result of structural forces that advantage some group over the others. Third, far-right groups and activists are quite suspicious of liberal democracy because it is seen as undermining the emergence of a homogeneous folk or nation. As soon as you have liberal democratic frameworks and processes, it, if practiced well, means that you have minority rights, that the individual is protected over the collective to some extent. So liberal democracy is not the way to go because it can't generate this homogeneous group of people that far-right activists and parties these days aspire. I think they moved away from a clear global racial hierarchy. So there are many far-right people who would say now, we don't have anything against Africans or Arabs, but they should just stay amongst themselves. As we stay amongst themselves. We can all live in peace and harmony. And finally, conspiracist thinking frames the way that the social is approached across the right, even if the conspiracies vary. And I think you see that even in Africa and other places of the global south, these are bits and pieces to which some people might be able to reach out and make them work for them in a way or another. Modi in India is a very good example here, where I would say his Hindu nationalism and what you see here is very strong overlaps. So we don't have comparable ideology at work in Africa anyway. I don't want to imply that, but certain actors may reach out to those bits and pieces. Also think about far-right thinking as much broader. So you have evangelical churches that connect Trump's America, Bolsonaro's Brazil, and anti-LGBTQ and other kinds of, I would say, regressive movements in Africa. So the evangelical churches are really important. You have the libertarian strand of the far-right ideology represented by star psychologist Jordan Peterson, who here is shown with Marguerite Wade, a Senegalese entrepreneur who has championed the cause by saying we should forget about colonialism and embrace liberty, the liberty of capital in the very first place, and everything will be fine in Africa. And this is why Jordan Peterson is so happy. And at the other end of the so-called manosphere, he's the intellectual representative, the professor. You have people like Andrew Tate. You would think Andrew Tate has no fans in Africa because, his audience it lies in North America and Europe, but you are wrong. Look below YouTube videos of Andrew Tate, look at Reddit threads, or look at copycats like Erica Munga from Kenya. And this is a report on the manosphere in Kenya. So these branches of the far-right ideologies have also captured energies and sentiments in Africa. The second one, and I don't think anyone except probably descendants of settlers, of white settlers, would embrace this kind of moment. It's one of nostalgic utopian desire. So there are right groups globally, and this is the most obnoxious example, who really have, selected Zimbabwe or Rhodesia as their kind of new Valhalla. And you may ask yourself, why do they glorify apartheid Rhodesia and not apartheid South Africa? Rhodesia much better fits their storyline. It's about a white settler regime that fought weak white people by declaring unilateral dependence from the weak motherland, Great Britain. It's much tinier, so it fought against all these hostile African nations surrounding it, a kind of bush war, and it really fits this precarious notion of the last man standing, becoming autark, very much building bridges to militia groups in the United States who like their weapons and who already bought their bunkers and whatnot. So Rhodesia, and this is, I think, the most terrible part, because it looks so flashy and so innocent, right, with the T-shirt. Rhodesia plays a real big role in far-right media campaigns, and many people don't know this. This is also not a swastika, so it's really an insider. If you walk with such a shirt somewhere in the US, we know how good US people are when it comes to geography, but I would even say in Germany, many people would not recognize what this actually means, but those who are inside know what it means. The third moment is what I would call the false friend syndrome, and it's very much related to Russia. We know that Russia has repositioned itself as a friend of African nations, especially West Africa, drawing on older relationships they had during the era of the Soviet Union, reactivating those, but also, giving it a kind of new pinch by sometimes spicing it up with decolonial thinking. And I think if you look closely, one has to become very suspicious because Russia is also supporting the anti-Black racist type of movements in Germany, for instance, like the AfD. And you see an interesting convergence here, Che events and Medvedev a few days ago when the German Constitution Protection Agency published their report that the AfD is now officially fully a far-right extremist party. Both of them came out and said this. But you can also look at the anti-Black violence in Russia itself, and I think many African governments have been totally silent about this. Since the late 1990s, dozens of Africans have been brutally murdered in Russia. It's institutionalized in the sense that even the Moscow Times, which is now branded as a foreign agent by the Russian government, recently published this piece after a Cameroonian migrant was brutally murdered in Russia, where they said few African leaders have acknowledged this problem, but these developments cast doubt on whether Black life is really cherished by Russian authorities. This is from a recent piece I wrote, and then I cite the newspaper. So I think Russia and Africa are also an interesting case. I don't want to homogenize, especially the European far right, because there's a kind of Westernist, Atlanticist extreme right, which is based on white supremacism and the West's indispensability to place itself at the helm of the new world order, and one that is more oriented towards Russia. I think the neat dichotomy is collapsing, but I think what unites somebody like Trump with somebody like Putin, or Bolsonaro with somebody like Putin, in a way is anti-Black and deeply patriarchal views on power, gender, and politics that are connecting these spheres. And the very last, a brief one, we all know that Silicon Valley has become part of the US government. The AI revolution needs resources, the expansion to Greenland, land expansion, and Canada might be seen in light of this. The recent deal in where did they do a deal? DRC might be seen in light of this. So rare earths, critical minerals, etc., are central in this geopolitical race with China about AI, and we are yet to see what this will do further, maybe even in more militant terms, to the African continent. If you want to read it up, there's a small piece in Pambasuka summarizing this, and another one in Endipole, which is really interesting, world building and world breaking. So the far right currently is very good at world breaking and partly also at world building. And the question is, what is to be done? Good. So that's it from my side.
Thank you very much. And our final speaker is Nicodemus Msika, who has an LLM in regional integration and EAC law, that's East African Community Law, at the Tanzanian German Center for East African Legal Studies, who's joining us online.
So Nicodemus, you may now unmute yourself and enable your video and also share your screen if you like.
They can control that.
Oh.
Good evening. Hello.
Hello, we can hear and see you, yes.
Good evening. Hello.
Yes, we hear you and we see you.
Oh, thank you. Good evening. Thank you. Thank you for this opportunity. My name is Nicodemus Msika from Tanzania. My topic is on the complexity that exists to the persons who are not Tanzanian nationals, but are refugees in protracted refugee situation. Tanzania, when you visit Tanzania, you will come across several people who are not Tanzanians, but have been in Tanzania for more than 10, 20, 50, and sometimes 60 years. These persons can be grandparents, great-grandparents, and the children as well as the grandchildren. Where do these people come from? When you visit Tanzania, whether physically or through different books and reports, as well as when you read the map, you will see that Tanzania has been surrounded by several countries, such as Rwanda, Burundi, South Sudan, and the Democratic Republic of Congo. So from these countries, especially from Burundi and DRC, the Democratic Republic of Congo, there have been several unrest and wars, sometimes civil wars, and other times they are not civil wars, they're just actual wars, and other civic tensions and several human rights violations. So from these countries, especially as I've mentioned, DRC and Burundi, you will see that there are several refugees who have been moving from these countries, moving to Tanzania for the purpose of seeking the refugee. When they have been given refugee, or you can simply say when they have been granted asylum in Tanzania, and they have sometimes they tend to overstay in Tanzania to the point that those who left Burundi and those who left DRC are in some instances not recognized as the citizens of Burundi and of DRC and the other countries. This is because of the issue of overstaying in Tanzania. So you might find that a young person left his country, and then after entering Tanzania, he or she formed a family. And then after forming a family, that family might continue generation to generation to the point that they lose ties with where they came from. So the question comes, the children born from such a refugee, and sometimes the grandchildren of such a refugee are left hanging on where they actually belong as citizens. When they're in Tanzania, they are being told they are not a Tanzanian, go back to where you came from. But this person has been staying in Tanzania, has become accustomed to the culture, the language, the lifestyle, and sometimes they own properties. And then when they go back, let's say to Burundi or DRC, they are being told, no, you are not a Tanzanian, you are not a Burundian, or you are not a Congolese. Go back to Tanzania because that's where you belong. The language that you speak is Swahili, perfect Swahili. You don't speak Belgium. You don't speak French. You don't speak English. You don't speak Congolese language, the local ones. Or you don't speak Kirundi, because they have this language in Burundi, they call it Ichirundi. So you don't speak even that. You are speaking the perfect Swahili. So you are not from our country. Go back to Tanzania. So there has been a way that you can see that the rights of these people have been swinging. They don't actually know where they belong. Even though sometimes they might claim that we are Tanzanians because our parents, our grandparents, our great-grandparents were in Tanzania, so we are Tanzanians. But at the end of the day, they are being told you're not Tanzanians. This Tanzanian Citizenship Act does not recognize you. So go back to where you came from. At the end of the day, these persons appear to be stateless because they are not granted rights of citizenship in Tanzania and the countries where they came from. So you might find these persons are not granted passports, birth certificates, and other rights, as well as other documentations that are to be granted to a person who is a citizen of a certain country. So, at the end of the day, as I've said, you find that Tanzania has a lot of stateless persons simply because the law does not recognize them as Tanzanians, despite being born in Tanzania, and sometimes they've been born from one of the parents who is Tanzanian, especially their mothers when they are Tanzanians. They're being told, okay, since your father is from Burundi or your father is Congolese, and then your mother is Tanzanian, you don't feature to be a Tanzanian citizen. So several rights have been infringed to these persons. So I'm basically conducting a research on the fate of these people. I'm not saying that I'm the first person or I'll be the last person to conduct researches on these people who have been unfortunate to become stateless by virtue of the civil unrest in their countries, and then because of the ambiguities and because of the legal gaps that exist in the Tanzanian laws, which does not protect the persons, the refugees who are in a protracted, or you can say, who have overstayed in Tanzania. So, what are the solutions? And so the impacts, the solutions, and the way forward is what I'm addressing in the research, and in the paper that I'll be able to submit to the University of Beirut, and then proceed to see the outcomes of the research that I'm conducting. So simply, what I can say is there is a need for Tanzania and the countries where the refugees in protracted refugee situations have come from to sit down and then determine the fate of these people. But aside from Tanzania and the countries where these refugees come from, it's high time for the global community, the African Union, the East African Community, the United Nations, and other humanitarian organizations to sit down and conduct a meaningful debate on how to protect these people who have become vulnerable, and they have been regarded as stateless. So that's what I'm focusing on, and that's what I'm researching on. Thank you.
Thank you, Nicodemus.
Thank you.
More fascinating papers. We have half an hour, and I know you have to leave at 5:30, so we'll make sure we get questions in. I think there are sort of many themes that emerge, but one is on the implications of the law, right? How do legal frameworks of citizenship produce racialized and exclusionary notions of belonging? There's a question of analytical scale, how do global dynamics around the rise of the far right or even refugee governance regimes actually mediate local experiences of citizenship? And then there's the broader question of if citizenship is more of a contested, everyday negotiated thing, how does the law account for defining citizenship in those terms? Let's open up to a round of questions. I'd say we collect about 4 or 5 questions to the panelists, and then we'll let them respond. So, yes, go ahead.
Thanks very much. That was a fabulous panel. Merle, I think you're quite hard on Germany. I don't think Germany's citizenship law is any worse than anybody else's. In fact, I can think of many that are far, far worse. I think we're on a continuum now. And to be also fair to Germany, I mean, historically, this has happened. Australia had a white, the white policy. The Americans banned Chinese people for a long time. There's a fabulous book called The Good Immigrant. So I thought as a cheerful thing, you might want to look at Antonio Pia has a wonderful, wonderful piece in LitHub called on Amo Afa, Amo the African, who was the first Black person to write a book actually about the treatment of the Moors, i.e. enslavement. And so I think that might be a nice way and then of distinguishing how actually we always think of progress coming forward, but perhaps actually the Amo Afa time, although he eventually went home because of the racism, wasn't something that was always part of German kind of culture. The treatment of other. So I think that might be worth exploring. Tshepo, I always love reading your stuff, and now I've heard you, I'm just completely thrilled. You just have such a wonderful way of conceptualizing and making me kind of frame, I just sat there thinking, social, spiritual, and the other one is just like, that's how I think of the Alexcor case, the mining case. And then you kind of framed that way. So I thought that was an enormous gift. I wanted to ask you a little bit between your kind of academic radical conceptualization and your job as a commissioner. How is being a commissioner on the Constitutional Commission working out in terms of these 5 crises that they said, well, since you know so much, you solve them? Or they just said, can you go and put him in a corner where he can write his papers and we'll present them, but they'll keep them out of trouble.
I think the question should be, how did Parliament pass his nomination? This is the more interesting question, right?
Could you add that as a Yes, so huge fan, that was fabulous. And then the paper on the Stefan's paper, I'm Zimbabwean. So for one of Toko's blogs, I've actually got a piece on Rhodesia during sanctions and the transition. And one of the things that's interesting to me, the way that you put it, turn Zimbabwe into Rhodesia. Well, actually, there's what Tshepo was talking about, liminality, Zimbabwe, Rhodesia. So when I first started high school, there was this little period of about 6 months to a year when we were called Zimbabwe Rhodesia, which was the inability to conceive of a move from white rule to black rule. So we had like a puppet regime that was acceptable for a time, you know, while everybody kind of got their bearings. And I hope in your paper with Jahandan to talk all, you know, to the African legal studies book or pamphlet that will be or journal that will be written. You will also make the connection actually between this global sense of Rhodesian entitlement with atrocities like Daniel Roof in America, the one who went and shot all these African Americans in a church because he'd been reading all this kind of racist white Rhodesian literature. So I think this hankering after the past can be seen in looking at a Clem Thollich song, Rhodesians Never Die. Because we're all Rhodesians and we'll fight through thick and thin, we'll keep our land a free land, stop the enemy coming in. And so who's the enemy? Yeah, so we the black people are the enemy. And this song is still really popular. If you look up the Rhodesian national anthem, Rise of Voices of Rhodesia, it's got hundreds of thousands of hits on an annual basis, partially because it's got beautiful pictures of Zimbabwe, you know, the falls and all those things. But there is still this kind of strong hankering. And Elon Musk has kind of fueled that with your first clip, you know, on Trump defense, the Afrikaners. So it's planted this idea of possibility. Yeah,
Fascinating. Maybe we'll take 1 or 2 more questions if there are. Yeah.
Yeah, my question is for the Prof about the definition you give on decolonization. I wonder if taking remembering as decolonization will not reduce its impacts. I mean, because taking everything and putting them in decolonization make that decolonization become more and more something like where we can't put everything in one word. I mean, I was thinking if in your writing or in your thinking, you are thinking to separate, to say, okay, decolonization should be one thing and remembering should be another thing, and they go to complete each other, not to be one single thing. Because there is a lot of most supporters are also defining decolonization in another way that is totally different from remembering.
My question will go to Nicodemus.
Yeah.
He really talked about Burundi. So
That was such a good person, you know.
So he can hear you.
Okay, just maybe that will be an observation or a point of reflection. Maybe you should also consider the pull and push factors in your study. Because the reason why Burundians are migrating to Tanzania is because of the political struggle. And then when they come back, it's because of those same political issues that make not them belong to the community. So beyond the citizenship legal aspect, you should also consider that, and maybe also issues related to colonial legacies. To what extent do they have, to what extent do they contribute to this situation of not belonging of those migrants? So 2 points. Thank you.
To quickly jump in, Nicodemus texted 2 minutes ago that he was losing the network. So this question he did not hear. But since you're both TGCL alumni, maybe you can just text me.
Thanks. Maybe we'll get a round of responses and I'll have another round of questions. So, Merle, if you want to start. I guess there was a question around are you being too tough on Germany and
I know you don't agree, but I'm just putting it, you know.
I might ask maybe if you can elaborate on the gender dimension of current German citizenship law. You were talking about men, unmarried, West African women and German men. Maybe those, I thought those quite fascinating.
Okay. Am I being too harsh? I personally don't believe so. I understand that probably other countries are not more progressive than Germany. Although if you look at a comparison for the countries in the European Union, Germany has significantly lower naturalization rates than other countries. Lower naturalization rates.
Okay.
Compared to other European countries. And I think what we were trying to do in our paper was also just measure the German legislator and government by their own claims and show that it is not as progressive as they said. Also because this reform was labeled as a modernization of citizenship law. So we thought it was important to maybe show that there are still parallels, that like there is no discontinuity between maybe colonial times and nowadays. So that was our approach. And to the gender dimension, there is a research assistant in Kassel, so the center of Germany, called Fatusila, and they work on anti-Black violence and law. And they did research on one Standesamt, yeah, like one authority in Bremen, where they rejected claims of women from Nigeria and Ghana that were trying to get birth certificates for their children that they had with German men, and where the authorities denied to put the men as the legal father on those certificates. And without that, you cannot like get the German passport. So yeah, that's part of their research.
We have a question on the radical commissioner. On decolonization.
Yeah, I mean, there's a far-right group, about far-right, that wrote an article about me saying the Human Rights Commission has been captured by radical wokeness, but they're quite right in the sense that I am trying to radicalize the commission. You know, from 2005, I've been working in both the university and in civil society. So in 2005, I was appointed as a national spokesperson for Khulumani Support Group, which is a group that is fighting for reparations in South Africa. And one of the tools that we used was the law. And we had a case in New York where we were suing multinational companies that supported apartheid, 23 multinational companies. But I always said that we are using the law tactically, not strategically. The law as a tactic, but not as a strategy. Meaning that we are using the law as part of other broad, radical tactics that we're using, marching, shareholder activism, and so many others, but also the law. And I still continue to do that. So at the commission, I'm a commissioner for anti-racism. And in my office, we use 5 tactics. The one is litigation. So, very, very pointedly going for institutional racism, moving away from interpersonal racism, but to focus on structural racism through litigation. How do we dismantle structural racism through litigation? But the second one is via dialogues. We believe in dialogue, so we'll sit people on, in a room like this and debate, very, very key issues about land dispossession, about racism in schools and so forth. And then also inquiries. So we establish, 6 months, 8 months inquiries or hearings on a specific things, about 5 tactics. So I joined the commission last year and we've had a lot of successes, So I spoke about 2 paradoxes in my talk. I'm also a paradox in the sense that I critique the constitution, but I use the constitution to support other radical tactics that other people are also using on the ground, So it is a paradox, but let's see. I've been appointed for 7 years. It's a 7-year term. We'll see what happens after 7 years. We'll see. But yeah, I get a lot of far-right people. Even now, they're going to be looking on YouTube. What did I say when I was in Germany? And they'll quote one thing, this person is anti-white. This person hates white people, But yeah, if we are serious about anti-racism, we need to tell the truth, and we need to really, 30 years into democracy, really try everything in our powers to dismantle not only internalized racism, but structural racism, even more importantly, in South Africa. Yes, decolonization is a negative. Remembering is the future. So, there's a tendency in South Africa to talk about decoloniality and decolonization as the emancipatory horizon. But that cannot be. Because as you say, decolonization is a negative, is your anti. But what is your future society? For us, the future society is a society based on Ubuntu that really remembers those worlds that were shattered, by settler colonization. And we always debate this question in South Africa: how does a settler become a native? Can the settler become a native? I'm going to answer that tomorrow. I won't answer it now. But it's part of this. How do you use Ubuntu, even as you are fighting unapologetically against white supremacy, against patriarchy, against homophobia, against ableism? So you're quite right, the two are not the same. The one is their anti, and the other one is your desires, ideal society. Absolutely, you're quite right, yeah.
There was no direct question, was there? I think maybe there's a good comment to further deepen the study of this. Yeah, it's also painful to look at all these things, but it's a deep hole, actually. And people are surprised once they start to research.
I may have a question around defining the global far right and whether that term is, you hinted at it and not wanting to homogenize the far right. Ideology does still matter, and are not all coming from the same place.
Sure.
Maybe how we might avoid the trap of homogenizing the global far right.
Yeah. So I think there's a good book by Rita Abrahamson and colleagues. So they were the first ones trying to take the study of, the far right beyond the, let's say, typical Euro-Atlantic geographies. And obviously there are ingredients which are very, very specific. So you cannot homogenize it. But I think the four type of commonalities I just showed are very good starting point. It's impossible to find far-right groups who do not think that inequality is a foundational principle of how you should organize society. They may allow for space within their own group to say, we try to achieve a kind of equal society amongst us, but they still need others to organize that type of inequality, and they would never invite those other groups into their own circle. So I think that is a very important commonality, and also, certain notions of maleness, masculinity, and strength, and patriarchy, and so on and so forth. I think is a second, a really important element. So yeah, of course, there are debates. What is alt-right? Is alt-right the same as far-right? And so, of course, there are all these nuances, but I think you need to study them from within. I'll give you a last example. The militia movement in the US, we often think they are far-right extremist groups, but it's quite a very type of movement, to the extent that you may have some kind of leftish militia groups in the United States, right? So this would be an example for me where you should not fall into the trap to say the so-called Rhodesia case is like the honeypot for far-right or militia groups from North America, because not all militia groups are far-right extremists. Right? So you have to be a bit careful.
All questions, anyone? Yeah.
Yes, I have a question in that regard, because you come from the geography, and I was wondering what type of concept does the new right has on territory? Because the old right has this very racist concept of Lebensraum, and I was wondering if there was a thing that is similar to that or very different to that in the new right movement.
Yeah. Take a round question. Otherwise, yeah. Maybe anyone other than Toko? Okay, go ahead. No.
Are you sure? Okay. Where do I start? Tshepo. Okay. Yeah, we were always trying to start a riot, and I'm happy that you still have that. Constitutions, right, are in many ways supported by a certain type of propaganda, right? And this, in large part, gives this feeling of belonging. But what happens when the material reality of people's lives and their interactions doesn't meet that propaganda? And so I take you back to 2001, and we were preached this gospel of the South African Constitution.
Amen.
It was the most beautiful constitution in the world, and yet 30 years down the road, we see in the infrastructure, in the lived reality of South Africans and the people that live with them, that this so-called nirvana was just a mirage. How do you then start to deconstruct and reconstruct that? What kind of legal infrastructures do you put in place? It's not a question, but something that perhaps you can share with us. And this takes me to Namibia. When you are busy having a good time in Ghana, and some of us were sweating it out in Cape Town, it was really bad, you know, but I took a trip to Namibia and say this to connect with an encounter that I had with Merle in Ubuntu. I visited Namibia and went to Swakopmund. Now, my recollection was that there's something amiss about this place, but I couldn't place it, you know. I went with a bunch of friends. It was a really good time. And then we went back to Cape Town. But this time around, I wanted to see what it is that I was feeling. So I went back to Swakopmund. I went to a town in Africa where I encountered people who spoke German. There was no hesitation to speak to me in German. A town where all the people that were walking around, going to the coffee shops, doing their shopping, were white. And then on the edge of the town were black people, going to their own shops, to their own churches, and all of that. And this reminded me why I felt weird in my body, but this time I could see it. And I wondered why this continues in Namibia 30 years, 35 years after independence. And so this discussion that introduced us to, that we have this idea of the constitution as the ultimate goal, that yeah, we have a new constitution, then the project is done. And yet in Namibia, for every kilometer you step on, we have not decolonized, and these constitutions should have no legitimacy. They have no business in governing these kinds of spaces. And so on to Merle and the work that you are doing to really reflect on these structures that are built into the law that cannot be dismantled by this kind of piecemeal reform that we are seeing. And it's true of citizenship law also. Sarah, it tells me to stop, but we can talk about this in the evening. Because I'm really interested in learning from you how we think about legal reform in a way that allows us to capture this sense of belonging.
Last comment, otherwise I'll go back to the panel. Any questions? Final question.
Actually had one for Prof. Stefan. Can I put it up? Yeah, okay. It was because you were talking on the rise of the global right in relation to Africa also. And I wondered whether, because you also talked about the commonalities they search and they try to put emphasis on. And I wonder whether sometimes the left does not do it this way and rather, or you can tell me what you think about it, but takes migrants' votes or people with different origins' votes for granted rather than searching commonalities. And this way, putting positive prejudice to people rather than searching the exchange with them.
Okay. Maybe we start with you this time and end with Merle.
Yeah, the spatial dimension on far right thinking, it's quite complicated, but there are two very important names, and one of them was already very important for the Nazis, which is Carl Schmitt. And he has been an important theorist of how you think together a homogeneous notion of the folk and the territory to which it belongs. And he clearly tried to carve out a spot for the German territory that, you know, differentiates itself from the seafaring empires of the French and the Spanish and the English, to think of Germany as a firmly land-based nation that needs to be homogeneous and requires its territory. And Schmitt is not only taken up by now new far-right thinkers, but also Alexander Dugin, which is one of the key ideological inspirations for Putin, has been very much influenced by Schmitt's thinking. But Dugin has also been influenced by decolonial thinking, which sometimes creates these very strange, they're not alliances, but, you know, states of coexistence where people who actually don't fit together very well, if you take one angle, still are walking together for a brief moment. So I think that is very important. Dugin and Carl Schmitt is two voices that have been highly influential. And Dugin also says we need this approach of greater civilizations, clearly demarcated spheres, where these greater civilizations don't mingle with the affairs of other civilizations. And this is now where Trump and Putin in a way meet, right? Because Trump also, in that kind of original Monroe Doctrine type of approach, has a similar understanding of the world, I would say, and his ideological inspirations. The left and the right, good question about how the left in maybe the US, North America, and European countries how they approach the migrant vote, right? I don't have a good answer. We have to be a bit careful with equalizing those two poles because the cores are very, very different, right? So the left at their core has no ideology of inequality if you take it serious. On the contrary, it's an ideology of equality. But this is very different from the far right. And I think the success recipe for the far right with migrant votes is that they have a buffet of different foods that are quite appealing. It's not just anti-immigrant, it is pro-free market, pro-masculinity, against feminism, pro-family, against taxation, against a state that meddles in your life. And of course, there are many migrant people with a migration background that can resonate quite well with these things. Nothing protects you by virtue of your race or ethnicity. Do not buy into these things. I mean, who leads the Tory party? Or who has repeatedly led the Tory party? Now it's a UK Nigerian lady. Well, but she has many anti-black and anti-brown policy stances. So I think the far right has been very successful in what I would say is an intersectional form of politics.
Yeah, and I was asking whether like the left's task should be to rebuttal this, and if they're failing at doing so because they're not finding those comments.
Yes, I would fully agree that they are failing or have been failing to, in a way, think about an intersectional politics of mobilizing the masses. After the financial crisis, this could have happened, but it didn't.
Matt, do you have to go, or can you wait? Or would you want to say your piece and go?
Yeah, thank you, Toko, for your comment/question. I'm not sure. So I would agree that piecemeal approaches and reforms do not dismantle structures. I think for the question of citizenship law, it's always a question of political realities, because the ruling parties are always set on securing majorities for their reforms. And I think this was also very obvious in the last one, where the Green and the Social Democratic Party had to convince the Liberal Party to actually agree on the reform, which was then done at the expense of marginalized women. So that was the result. But I think that's also done because there is no vote for foreigners in Germany, so their opinion, their vote just does not matter in the end, because if these people are neglected, that will not end up in the election, it will not show there. As to, I don't know, I don't really have solutions for this problem. So far, as an early career researcher, I've focused on identifying and dismantling these narratives that accompany these reforms. So I think if you actually look at each and every one of the prerequisites in this right to naturalization, I think you would find almost all of them problematic and that they should be abolished. I just don't know if that's realistic, that will ever be put into practice. No?
Very much.
No, I agree with everything that has been said, especially the piecemeal critique. We talk about the need to fully decolonize Africa, but there's also a need to fully decolonize the West. What we talk about in Germany is a case for decolonization of Germany, but we talk about how do we further democratize through liberal reforms. That's a mistake. We should really be talking about what does it mean to decolonize the West? Fundamentally, because that's what we're talking about here. You're quite right. South Africa is based on the propaganda about Mr. Mandela, propaganda about the TLC, propaganda about the Constitution. the constitution does not have a word in it called apartheid or colonialism. What kind of constitution is this that does not contain the word colonialism, let alone apartheid? That tells you a lot, right? Secondly, a constitution that does not talk about reparation, talks about something called socio-economic rights within available resources, but not a reparative justice at the heart of it, So when we understand belonging as material and affective belongingness, Black people materially don't feel a sense of belongingness to South Africa because of the huge impoverishment that is contributed, but also affective, as you say. You talk about, Namibia. I don't know why you feel the same in Cape Town, because in Cape Town you feel this sense of, you are in Europe, not just Namibia. I mean, in Cape Town itself, and that's the thing that we're talking about when we say, what does it mean to decolonize South Africa fundamentally, but without saying the settlers must go away? What does it mean to deconstitute and reconstitute society fundamentally, to build a society built on Ubuntu? Absolutely. But the question that you should ask yourself is, the propaganda did not come from South Africa. The propaganda came from the UK and America about South Africa having a miracle transition, about South African constitution. Why were American and European academics and scholars so, concerned about propagating this myth? That is a real question, and that's an interesting question. Thank you.
Thank you very much. I realize in all of this we didn't speak much about the state and who the state is and what that means in the context of refugees, in the context of post-apartheid or neo-apartheid South Africa, or in the context of we did mention walking through the institutions, and I guess there's something there to hold on to. But yeah, thank you for listening. I thought it was fascinating. I learned a lot, and let's applaud our